Hello, everybody. We're just getting started here. Want to make sure my technology is connected. This is Paul at Barth Calderon, and fired up that you're here, and really excited about this event. For those of you who might be seeing this for the first time, we're streaming this everywhere. So we're on LinkedIn, Facebook, YouTube, Twitter, everywhere. And this is a special show because I've got two really incredible attorneys together: Steve Williams, landlord attorney; Brad Barth, asset protection attorney. If you own a business, property in particular, this is an incredible webinar to listen to. And if you're an advisor working with other people, you want to check this out. And as always, reach out if you ever have any questions. We have a complimentary one-on-one planning assessment we do for everybody. And when I get into this show, you'll see how to get that going. And also around this video, wherever you're watching it, either up here or down below, there's a way to contact us. And yes, over here, that's where we're headquartered in Orange County, California, the 20th floor up here. That light on in the corner, that's me. I'm always working late. But thank you. Let's jump into this. Let me get it going here. Hang on one sec. Okay, give me 1 second here. And gotta stop my video. Boom.
Hi, this is Paul Hitchcock. Thanks for jumping on Wealth Protector TV. Have a great episode for you today. I've got two great attorneys, Steve Williams, who's a landlord attorney, and Brad Barth, who's an asset protection attorney. Got them in the same room for a high-level discussion on protecting your property and dealing with tenant issues. Let's go take a look. Thanks so much.
Steve, this is Paul. I have a question.
Yeah.
Is when you're dealing with mold claims, what's the how does the origination of a mold claim happen? I mean, a tenant feels that there's mold. Do they notify the landlord? Are you seeing right away they get an attorney? Is it, are they looking for money? I mean, what is the first step of that process?
Yeah.
That you typically see?
Sure. I typically see complaints from the tenants about mold growth. And the common contributing factor are really two things. Well, it's moisture, but it can be a broken pipe, some leak, some source of moisture. Water's infiltrating inside a unit through a defective roof or something of that nature, or just improper ventilation inside the unit, which could be contributed to the tenant's failure to ventilate. And that's the most common type, where you just have a lack of ventilation, and maybe it tends to grow around surfaces where there's a lot of moisture, like I said, in bathrooms or kitchens. And sometimes if there's a lot of clutter inside a unit, and maybe a lot of you who are watching now have seen, like if you push a bed up against a wall tightly, and maybe it's located or directly underneath a window where there tends to be a little more moisture, well, you pull that bed out, there's been no ventilation between the wall and that bed, and sometimes you'll see some surface mold growing. That's not uncommon. So I do see that, and that's typically handled just wiping it down with a bleach solution. That typically eradicates or alleviates the problem.
But then when if there's a claim, so somebody says there's a claim, and you have a landlord coming to you, when the landlord's coming to you, is it because there's already a lawsuit going on, or there's just a sniff of a situation and they're coming to you to ask how to handle it? And then I was going to parlay that into Brad, is okay, let's say there's a mold issue that arises, because I've heard you talk offline that some of these mold claims can rise to a multi-million-dollar lawsuit for respiratory issues, lost wages, all that stuff. So, Steve, if you're getting that, at what point are you seeing that? Is there already a lawsuit? And then, Brad, the follow-up is, what does asset protection do to kind of prevent, before something happens, somebody getting attacked for a mold claim on their assets?
Okay.
Yeah, so to answer your question, I see both. For the most part, I see it at the preventative stage. The landlord comes to me saying the tenant's complaining about all these problems. What do I do? The first thing I recommend is that we get in there, and maybe depending on the situation, you have a mold remediation professional or a company come out there and advise, what needs to be done. So you're doing everything by the book and as recommended by a professional. That being said, I also see it when it comes into my office as a lawsuit. I see that quite frequently as well, and that's usually in those situations. I do see that there could have been a situation that was addressed earlier if they'd come to me earlier. So usually a lot of back and forth between the landlord and tenant before it rises to that level of a lawsuit. Maybe the landlord thinks they can handle the situation, and sometimes and oftentimes they do. Sometimes they don't handle it to the tenant's satisfaction, and it comes to me as a lawsuit. And the first thing I do there is I say, well, let's take a look at your insurance policy, get some coverage that will help defend that lawsuit. Oftentimes there are mold exclusions from lawsuits, so that kind of segues into what Brad may have to say. Well, how can you protect yourself from this type of a lawsuit in the event it does get to that level?
Yeah, Brad, what do you think?
Yeah, sure. Well, first of all, I just want to take this opportunity to say thank you for everyone for taking the time to listen to this presentation given by both Steve, myself, and coordinated by Paul. And I think all the points that Steve's making are absolutely correct and critical. I mean, we have dealt with a lot of mold-based clients, mostly taking place in the northern areas, especially here in Northern California. And as I was listening to you, Steve, I was thinking about a client I'm dealing with right now in the Oakland area that has this exact issue, dealing with the tenant inside a marketplace. And what I find that one of the most difficult challenges about the mold issues with regard to the breach of habitability that you mentioned is that what truly is the cause of the client's or the plaintiff's respiratory or whatever the mental, however that mold manifests itself. It's hard to find out what the genesis of that issue is. It's a very not very clear area, right? Because some people are saying I'm having these anxiety problems, I'm having these respiratory problems, and it's all mold related. And then, well, the landlord is, well, maybe not. Maybe these are things that you had prior to coming to us, living with us, and now it's just manifesting itself because of just time and age and issues of things like that. So I find that this mold issue seems to really open itself up to a lot of ambiguity, which makes it all the more difficult for our landlord clients to really kind of defend themselves. And to your point, in light of the California tenant-friendly environment, it does seem like the burden is on the landlord. And you're quite literally, as the old, you're guilty until proven innocent. It's nice to hear that California has passed some laws that do put some of that personal responsibility on the tenant, but we'll see how that kind of plays out. That's more your arena than my arena. And so from a protection perspective, and there may be some exclusions in particular policies that would prevent the mold from being a covered event. And then if that is the case, then you want the landlord certainly wants to make sure that there are some protections in place to prevent that mold liability from getting to them personally. And that's really what asset protection is all about. And so whenever we're dealing with asset protection situations, whether it's tenant-based issues, it's property-based issues, it's business-related issues. I mean, think of an insurance policy. We all rely on those insurance policies to be our first line of defense, at least to mitigate some of the damages. And just look at a car. We all have car insurance because you have those unforeseen examples, those unforeseen events. But at the same time, just like in the mold example, there are particular exclusions, even in for all types of insurances. And if that is the case, then now you have a structure should be in place to help to limit that liability. And fortunately, our clients, a lot of our clients have real estate as part of their overall portfolio. And not only is it a great source of potential income for them, as far as income and future appreciation of assets, but it's also the largest source of potential liabilities that we deal with. Because there really is there's an uncontrolled element here, and that uncontrolled element is the tenant. You just don't know what the tenant's doing. You don't know what activities are happening on the property. You got this ambiguous mold thing. Is it truly a mold problem, or is it something else just manifesting itself? So the real estate is a great source of investment, but it also does come with these liabilities. So if insurance isn't going to be there, then you better have some structure in place, not only to mitigate or limit that liability from getting onto you personally, but even if there is a personal liability for whatever reason, perhaps there's a lack of structure, then something should be in place to mitigate your personal exposure as well. So from my point of view, when we work with our clients, we're looking at asset protection in two different perspectives. One, the activity itself. In this case, it may be a rental property, right? So making sure that rental property is insulated from the client individually. And then you also have to worry about the client themselves individually, their personal residence, their stocks, bonds, cash, retirement, other business interests, things like that. So it's so there are multifaceted ways that we deal with that. But to your point, Steve, when it comes to dealing with real estate, there's also, I would say, multifaceted sources of exposure, right? So it's important that people like you and I work together to help our clients.
So I got a question about that. So if it is ambiguous, Brad and Steve, someone has a mold claim and it's hard to determine what's going on, how do you settle that issue? I mean, is it the attorneys getting down and dirty and trying to figure it out? I mean, or does it go to the courts, a trial? I mean, how do you make sure that it's done right?
Steve, I'll let you start with that one.
Sure. So, and Brad raised a good point earlier that typically when there's a tenant lawsuit, the plaintiff, which would be the tenant in that case, is the party that has the burden to prove the liability and the damages. The problem is that one, you have strikes against you. One, you're a landlord. Mm-hmm. And, just with the tenant-friendly laws, there's going to be a strike against you as being a landlord. Two, juries, especially where I practice in the Bay Area, San Francisco, Berkeley, Oakland, those jurisdictions, the vast majority, the majority of the jury is going to be a pool of tenants. Mm-hmm. The third strike is, there's a negative connotation with mold. Everyone hears the word mold and they get shivers. And so whenever there is the existence of mold, and typically the tenant will bring in some, photos showing how pervasive the mold is, that doesn't look good. So to answer your question, how do you resolve the liability or the proving of how the mold impacted that person directly? Well, in the lawsuit, there's a portion of the lawsuit, the pre-litigation, called discovery, where both parties get to ask questions, request documents, ask for proof. So all the documentation and evidence is submitted to the parties before the trial. And then it would come down to the judge or the jury to listen to all the facts and contributing factors. And when a tenant is claiming, injuries because of mold, health issues, that opens up that person's potential medical history or medical past, such that you can see, well, maybe there's some other contributing factor that caused this person's illness as opposed to mold. But at the end of the day, it would come up to just the trier of fact, which would be the judge or the jury, to decide whether or not the mold was the cause and effect of the person's illness. Being said, the vast majority of these cases, before it gets to that point, because parties know the potential risks, the landlord, the potential liability risk, and the tenant, maybe they do have some other health factors that would diminish the possibility of them prevailing. So typically it ends up settling with the landlord writing some check, and they're not small checks. Typically, in what I'm experienced up here in the Bay Area, to the tenant to resolve the case.
Yeah, and I'll totally echo everything that Steve just said, but I'll also make cite a quote that Steve said. He said that litigation is costly, right? And that just plays into what he just said about, you know, the settlements, because as things kind of progress, maybe the landlords are able to you know, to justify or to prove that it wasn't the mold that caused it, was something else. At what expense is that going to be? And so, but he also said that the landlords may wind up cutting a check to settle out, and maybe a bit of a larger check than what they wanted to. And I think this is a bit more where we kind of come into play for our clients, because asset protection really is designed to put our clients, in this case, and you know, the landlords in this particular conversations, into a position to enter into a fast and favorable settlement. In other words, a more favorable settlement than they would have been in without the asset protection in place. Because when you get attacked, you really do feel like you're on the defensive. And Steve had mentioned already, and I will definitely echo with that. No, it is a tenant-friendly environment, and especially demographically from where he's located, it's also a jury pool tenant-friendly environment. Ultimately, the landlord wants to be in a position to not, if they have to write a check, to write the smallest check possible. So remember, you got two different sides of this transaction. So not only do you have a cost to the landlord in defending this, you also have a cost to the plaintiff in pursuing this. In most of these cases, Steve, correct me if I'm wrong, I'm assuming that these are being done on a contingency fee basis. Is that correct?
Generally, yes. Yeah, I'd say across the board, yes.
Okay, so now you have plaintiffs' attorneys who are basically funding these plaintiffs' litigation in the hopes of receiving 30-40% contingency fee. And so when they themselves, through the discovery process, realize that in order for them to, even if they win the litigation, if they find that they're going to have a whole nother battle to try to collect on that judgment, then they themselves realize that they need to get out of this as quickly as possible. And again, this is where some of the asset protection kind of comes into play. When they realize that when they win the lawsuit and they have to work all the more harder to collect on that judgment, they also may be encouraging their clients to go ahead and settle out, just because of the challenges that they may deal with in the collections process. And so that's where, again, where the asset protection really shines. It gets you in a position to negotiate a faster and more favorable settlement with the plaintiff than you would have been without it. And again, it's nothing to do about whether or not you get sued. We can't control that. What we're trying to control is we're trying to, if you get sued, to how quickly can you get out of this thing, and how little can we get you out of it for. And that's kind of where we play in. So again, I think it's a little bit of both. I think it's the totality of the circumstances to what Steve said as far as litigation is expensive, but yet we want to kind of encourage that through some of the structuring that we put in place as well.
What happens with the insurance company in a mold claim? You know, if there's insurance there, do you call up the insurance company and what's their reaction? Is the guy like, whoa, mold claim, you know, we got to figure this out? Are they hesitant? Or what actually happens in real life when you call the insurance company about a mold claim?
Yep. So the first thing I do when a lawsuit comes in my office, into my door, the first thing I do is I ask for a copy of the insurance policy. And this is important. Everyone, whether you're a mom and pop landlord or a large scale landlord, you need to have coverage for what's known as personal injury liability, a landlord policy. Sometimes you get owners who get just a general homeowner's policy that doesn't include any landlord protections, some liability protections. So that's important. And first thing I do is I take a look at that policy and I do what's called tender the lawsuit or the claim to the insurance company. That out the door, almost as soon as my client exits, I'm getting that document or that letter, the insurance company in writing saying, here's a lawsuit, you cover the property and the insured, defend this lawsuit and indemnify my client. Then there's usually it's a couple weeks before you hear back from the insurance company, and I always, they may call and him and haw about it. I always tell them, put it in writing, and they will do what's called, it's either a coverage determination or a reservation of rights letter, and that will spell out their determination of the policy, there are claims being covered under that policy. And ideally, they say, well, no, you're not covered for this, and this, but there's one sentence here, you may be covered. Because of that, we're going to provide a defense. That's my main goal, is to get the insurance company to defend the lawsuit. Let them handle the defense at their cost and hopefully resolve or settle the case at their expense. Every now and then you will get a complete denial from the insurance company. And at that point, then I have to look more closely at the policy and determine whether or not their determination was proper. That's typically the way it's handled in my office.
Steve, in your experience, when you've dealt with insurance companies, even under this reservation of rights letters, do they also have like adjusters come out and say, although you're covered for this amount, we're going to adjust the amount that we will insure for? It's
interesting. I'm right now in litigation on two cases that I was just dealing with just yesterday. Mm-hmm. Yes. So what will happen is, ideally, like I said, the insurance company assigns a defense counsel to defend the lawsuit, and that defense counsel represents you, the landlord, the insured. Mm-hmm. Royalties are to you, but they're being paid for by the insurance company.
Right.
Also, there will be an adjuster assigned to the case that will oftentimes, tag along at any mediation or be involved in any settlement negotiations and say, well, the insurance company is willing to contribute X to settle this case, mm-hmm. as long as you insured contribute Y to settle this case. We'll contribute 80%, you contribute 20% or 90 or 10, mm-hmm. whatever it is. So at that point, it's good. And typically the attorney who's assigned to defend the case will not get involved with that. So that's where it's a good idea to have personal counsel.
Right.
Then evaluate, well, you know what? No, the insurance company needs to go out. They need to protect you. You're the insured. They need to protect you from this potential liability. Do their job. Or, look, you're hanging by a string here on the covered claim, and you may have some real exposure to liability.
Right.
Maybe you should contribute something. And that's really by case determination.
Yeah. Well stated. Do you ever in this space in the landlord tenant? The landlord insurance space, do you find a lot of or any insurance bad faith claims?
I don't come across those a lot. Typically, when you push the insurance company far enough, mm-hmm. in mind their whole job is to make money and eventually deny claims
and not pay out money, right?
Yeah, but when you start to press bad faith.
Right.
Sometimes they may actually step up and defend the claim with a reservation of rights. But I have litigated my fair of bad faith claims as well. But those are fewer and further between. Yes, it can occur.
Yeah, I think what you said is very wise. We do quite often counsel our clients to have independent counsel to kind of oversee, because there is an inherent conflict of interest when the insurance company themselves is providing the defense counsel. So it's not a bad idea. So even though they may have counsel provided for them, to have another lawyer just on an hourly basis every so often to kind of pop their head in, take a look at the papers, just to make sure that everything's on the level. So.
Yeah, I agree. And we do that a lot for clients, and we can be involved, like you said, just overlooking, looking over the shoulder of the defense counsel,
right.
more proactive, or actually be the lead in the case. It just really depends on the situation and the client, what the client is more comfortable with.
Yep, agreed. Well said.
I was going to ask, and this is a question that came in before the webinar, we were taking some email questions, is agent or broker liability. So if there's an agent who's, selling the property, representing, are they exposed to anything here? Let's say they sell it and something happens soon after the sale of the property. Is there exposure for those people?
Well, yeah, there is. So typically agents have liability policies as well to protect against those types of claims, but they do as well have potential liability if they're aware of a condition existing at a property that they're involved with the sale or the purchase. Maybe they're representing the purchasing owner. Then if there's something they're aware of that may impact the value of the property or impact the property in an adverse way, then they would also have a duty to disclose that information. And if they don't, there may be some liability. Yes.
So Brad, I was going to ask you this question because this came up recently where there was a broker sold a property and there was some issue with flooring or something, and they were sued. It was like a $3 million lawsuit. They were named personally in the lawsuit, even though they worked for, a brokerage. And they started getting nervous because they had no asset protection, and the spouse owned the business. And so, describe that scenario, because to me that was unreal and crazy.
Yeah, no, I don't know exactly how the employment arrangement works with realtors and brokers, but I would think that they were probably 1099s, independent contractors with the broker. And so if they're acting in their individual capacity, then like any other sole proprietor, they would have unlimited liability for the totality of what they're doing in that professional course and scope. Whereas if they had a individual corporation that they incorporated themselves and then they were 1099ing with the broker, with the corporation, then I think they would have some limited liability on what they're doing. But again, I don't know how brokers, whether it's Keller Williams, Prudential, 21st Century, I don't know exactly how they work, whether that's allowed in their arrangement. I don't know, but I would think that I could easily see how an agent would have personal exposure, and we've worked with a lot of them, not only at the broker level, all the way up to the financing level, because the personal exposure that's involved. But back to what Steve was saying about those latent defects versus those obvious defects, I think that Steve, how would a property inspection, do the property inspectors, are they just looking at electrical work and structures, or are they now trained to see, hey, I see a mold problem here too, and put that up on their report that everyone has to sign off on?
Yeah, they'll typically do a pretty thorough inspection of the property. And yeah, they just look and see what's visible. So if there is something like mold growth, then that will definitely show up on the report. And that may lead to, well, what was the cause of that mold? Is there some broken pipe possibly inside the wall, or some source of what's the source of the moisture? And then that, once you're on notice of that, then you most likely will have to do further investigation, explore, find out that there are further, more substantial problems that just weren't visible to the inspector.
Right. So once the buyer is on notice, does that relieve the then seller of liability? Because hey, it's on the report, you knew about it. You can't come up the chain of command here to try to come after me as the previous buyer. So their liability is, the previous seller. So that cuts off their liability. You agree with that?
Generally, yes. Once a buyer, so the whole part of the purchase sale transaction is that the seller disclose. Disclose.
Right. So back to Paul's question then.
Yeah.
So assuming you have disclosure, would that disclosure then also relieve the broker of liability?
Most likely, yes. It doesn't mean you're still not going to get sued.
Totally. Yeah.
In California, you can sue anyone for everything, and there's nothing that's going to prevent that. Generally, so long as there's been full disclosure and the buyer elects to proceed in light of that disclosure, they're taking it, as is, so to speak.
That's right. Caveat emptor. That's right. So, Paul, I think to answer the attendee's question, I think that yes, there would be broker liability, and I think that would be an unlimited liability so long as they're acting in that broker capacity as an individual. If they aren't already incorporated with their broker, again, I don't know so much, but there are ways to mitigate their liability based upon exposure of known or reasonably ascertained defects, such as what we just spoke about, the inspection. But I think that their liability could be minimized if it was latent and nobody knew about it, right? Because it's undiscovered. And if something pops up a handful of years later, then I don't see how that could tail back all the way to the broker if they themselves at the time of sale had no knowledge or appreciation of the risks upon sale.
Right. Steve, when you're going about your business, obviously you're working with a ton of property owners. That's your focus. Are you seeing that most of those owners have a protective legal structure around their property, like an LLC? I mean, when you're going to, what do you notice?
Yeah, so the smaller landlords, no. I rarely see that with the mom and pops or just a few units. The larger landlords, yes, I am seeing some form of asset protection, the form of like an LLC, a limited liability company, as the owner of the property, as the title owner. Typically what I see in the smaller landlords are a lot of individual owners and a lot of trusts, so into a living trust. So the owner transfers or buys a property to be held in the name of their trust. And Brad will explain right now that generally my understanding is that there's not a lot of asset protection in individual ownership or ownership in a trust. Is that true, Brad?
Yeah, that's great. And so addressing both those issues, and I agree with you that the smaller mom and pops are taken in their name individually. And as I mentioned previously, that a lot of our clients do have real estate as part of their overall investment portfolio. And I did mention previously also, but it's also their primary source of liability because of all of those unknowns. And I can't tell you, Steve, time and time and time again, it's because the property is in their personal name. Their entire net worth, everything they've worked so hard for, is completely at risk simply because they didn't take some affirmative steps to put that property in, as you correctly identified, in an LLC. It is the proper structure. And we do also get a lot of pushback saying, well, everything's inside my family trust. I don't have to worry about this stuff. And you also correctly stated that a regular revocable living trust, your typical estate planning trust, does not offer any asset protection. And the reasons for that is just a matter of dominion and control issues. A revocable living trust is typically created by, let's say, in this case, the landlord creates it, in their individual name. They actually are acting as the trustee, so they have the full management and control. They retain the power to revoke it and modify it. They are the beneficiary of that trust. So effectively, there really isn't any difference. There's no distinct entity in a trust realm between them and the activities on the land. And so that's why if it's in their family trust, it's great for probate avoidance. It's great for orderly distribution of assets through an estate plan, but there's zero when it comes to asset protection. Now, that being said, however, there are certain types of trusts that do offer asset protection. It's not your common family trust, but there are a handful of trusts that are used primarily in the more advanced estate planning areas, where some of those characteristics I just mentioned, as far as trustee, beneficiary, revocability, some of those are kind of mixed up for different reasons. And the consequence of that is that trust now would be deemed a separate entity, and then one step removed from the landlord, so they would not have personal liability. So I agree with everything you said, and an LLC is the proper structure, and I don't know reasons why people don't do this when even the small mom and pop, because it's really all not that complicated, and creating LLCs has been pretty commoditized over the years. So it's not something that people aren't readily aware of or don't have access to. And even if you look at a cost perspective between setting up something here in California, albeit one of the most expensive states in the country, to operate an LLC, just because of the franchise tax annual fee, even if you just, I tell my clients, raise your rent to $100 a month. And you cover all your costs, so, or $75 a month to cover all your costs. So this is an example of where you're a penny wise and a pound foolish. If you don't want to create an LLC because you don't want to pay California $800, then you're in the wrong line of business.
So I get, like I said, that there's a lot of potential liability. And let me just give a case example, and I want to follow up in a minute, Brad. I had a client who was being sued. It was by a group of tenants. I think it was about 10 or 11 tenants, all claiming habitability issues. And that one went to trial. At the end of the day, the jury found the owner liable for It was about $100,000.
Mhm.
Pursuant to the local ordinance here, that was tripled, so about $300,000, which is not an uncommon settlement these days to resolve these claims. But here's the problem. The owner was on the hook for attorney's fees. Even though the total liability as determined by the jury was $100,000, the attorney's fees were $1.2 million. So just to emphasize the point that these lawsuits are oftentimes attorney fees driven. He's looking to get paid. Actual judgment for that amount against the landlord. And sometimes the award may exceed the policy limits of the insurance. Sometimes, like I mentioned earlier, the insurance may not cover a claim or a lawsuit. You know, if they have the wrong policy in place, and I meet with them and I cringe because I know this is going to be very expensive. It's oftentimes for a mom and pop owner. So Brad, if that was to happen and the owner at that point was not asset protected, they owned individually in their trust, is there anything that can be done after the fact? Is there anything that you can do once that lawsuit has been filed?
Yeah. Okay. So this is one of those real sensitive and gray areas, and so this is where people want to seek professional advice. Okay. This is where you don't do internet research, and many times I spend more times counseling my clients to try to get them to unlearn all that they've learned from what they see on the internet. So the idea is just because you can't do anything, it just means that anything that you do is going to get it's going to be scrutinized, right? A much higher level of scrutiny. So the clients are able, post-complaint, not post-judgment, post-complaint, they are able to still do some asset protection. It's just that you have to be very careful because everything that you do, entity formation, property transfers, are going to be highly, highly scrutinized and certainly attacked by plaintiff's counsel. But you also have to know, Stephen, you know this, and you said it earlier, not only is litigation expensive, it also takes a long time, right? Yeah. So it's timely. And so you have to remember that if litigation goes on for a couple of years, there are certain things that people do in the normal course and scope of their business activities, the normal course and scope of their family activities that people do. I mean, such as, you can create an estate plan. I mean, you can buy an insurance policy. You can buy another piece of property. You may want to take a home equity line so you can finance the purchase of another property. You can contribute to your 401k plan. I mean, there are things that are done completely outside of the area of trying to hide your assets from creditors after the fact. So that's where it's important that you have that proper balance in working with a proper professional, is because if anything you do post-complaint is going to be scrutinized, you better have an answer for what you're doing other than, I'm doing this for the sole and exclusive purpose of trying to avoid paying my creditor's claim. So I guess that's my answer. And there's a real fine balance. And that's one of the areas where working with an experienced professional helps, because people can get in trouble here, right? I mean, not only the clients can get in trouble, but the lawyers can also get in trouble if you're doing things that are unethical, right? But also just remember, the wheels of justice turn slowly, and life goes on. It just means that like I said, sometimes hindsight, they look back at you. You just better have a good answer for them.
All right. So it sounds like the important lesson is be proactive. And
absolutely. Going back to that insurance policy, right? I know that every time I bought a piece of property and I had my property insurance people come out, they came out with cameras. They took a picture of the crack in the driveway. They took a picture of this crack and this stairwell, and they took pictures because what they were saying is that, you're covered, but I'm actually carving out these specific exclusions because these are pre-existing conditions. So you can look at a lawsuit as a pre-existing condition, and you can look at the asset protection structures as the insurance policies. So you can have the insurance in place, but if you have a pre-existing condition, a lawsuit, it's going to be excluded. It's not going to work. It will certainly work for future issues, but it may not be as effective against the current problems because they're excluded. So that's why asset protection just like anything else you do, needs to be proactive. It works great when it's proactive. There's a lot of room for problems and issues if you're doing it on reactively as opposed to proactively.
Fantastic. We're up against the time clock here. Steve and Brad, thank you so much. That was great information. And thanks everybody for jumping on what you're looking at there. Again, if you have any follow-up questions, or you're thinking about your planning, or you're in the real estate profession and you want to ask Brad or Steve questions, complimentary, text YesBC to 474747. You'll get a text on how to sign up for that and get that going. Thanks everybody, and we'll
Okay, thanks everybody for jumping on. I hope you got something out of that. And we do these a lot, and there's some great questions coming through. And on protecting yourself, on using a trust, LLC, those get fairly technical, and just making sure that's done right. But yes, the LLC integrates with a living trust, and then an LLC is very different from a corporation in the way they react to liabilities. And I mentioned inside versus outside liability. What our experts talk about is an inside liabilities. To clarify, that is something that happens around the property. Tenant lawsuit, dog bites, somebody falling off the roof, tenant has a party, people are drinking, shelf falling down, hurting somebody. Those are all inside liabilities, and the LLC is a wrapper around your property to contain an inside liability, where an LLC has a more robust asset protection feature is on the outside liabilities versus a corporation, where an outside liability is something that happens away from the property, a car accident. You have another business and there's a liability there, a tax issue with the IRS, wherever it comes from. You have kids, minors driving cars around, they injure somebody. So you have a liability to your family, could be your spouse or somebody else, but it comes to your family, and now you have a liability, and they're looking at your assets and they're looking at your property. And creditors love property, especially in foreclosure states like California. They can go in there and grab the property, foreclose on it. So that's an outside liability. LLCs also are a great asset protection vehicle for that. Think of a force field around the property, keeping the liability out, versus a corporation, where creditors take stock in a corporation all the time. They can grab it. Doesn't matter if it's not Disney or some publicly traded company. You have a corporation, you own stock, creditors take it. It's low-hanging fruit. Experts tell you this all the time. So sorry for the confusion about the guard assets versus YesBC, but if you text guard assets to that number on the screen, if you wrote it down, 650-459-2712, guard assets, you'll get a chance to get on the calendar, and we have a complimentary assessment. So thank you for being here, and we'll see you